Sir, hello. Sir, good afternoon, sir. This is Ram Koteswara, sir. Ravi, sir. Ravi Sam, sir. Sir.
Yes, good afternoon, sir. You are audible. Please go ahead.
Myself here, Professor in EC department, sir.
Okay.
We are looking up to this IIC, sir, Institutions of Innovation Council, NRI College, sir.
Okay, great.
So, respected resource person Ravi sir and coordinator of PDC Vijay Krishna and the department coordinators of IIC and EDC and participants. Good afternoon, all. And it's our pleasure to welcome you this session, afternoon session, and it's a part of Impact Lecture Sessions series. So this is the second session today, and one morning session we conducted in the morning, and 15 days back one more session 1, lecture series 1 we have conducted, and this is series 2, and under series 2 this is the second session, and these sessions were sponsored by AICTE, MOE, Minister of Education, and IIC. The sessions were sponsored, and certificates, all these things were provided by this MOE and IIC. So here we are inviting and expert eminent professors in the field of innovations as well as this entrepreneurship. And today's session, our the main resource person, our Ravi Sam sir, and I invite Dikshita of IEC. She is the coordinator of student coordinator, and she will introduce today's our resource person. So Dikshita,
thank you.
Please.
Thank you, Dr. P.R.
Yes, sir. Am I audible?
Yes.
Welcome, sir. Yeah, you are audible.
A very warm good afternoon, everyone. I am Dikshita Kanala from 3rd year ECE of NRI Institute of Technology. It's a great pleasure to introduce our speaker today, Mr. Ravishyam Madira, who is going to talk to us about intellectual property rights and patent procedure. He is a techno-legal expert with about 23 years of experience in Pharma Industry Association, responsible for corporate legal affairs, contract management, and intellectual property management. He is experienced in leadership team member and coordinating with senior management for strategy planning and decision making, intellectual property rights management, and also he has vast experience in contracts management, client negotiations with various domestic and international clients. He worked as the head of the Department of Intellectual Property Management and Legal Affairs Stripes in Acrolab Limited, Bangalore. Served as manager in the Department of Intellectual Property Management at GVK Bio, Hyderabad. Worked as an executive in Department of Intellectual Property Rights in Shanta Biotechnics Limited. He is currently working as a director at Jubilant Biosys Limited at Bangalore, and he plays an important role in intellectual property management, working closely with scientific teams for IP mapping for discovering programs, preparation of target-related IP landscape, also playing a key role in corporate legal affairs and contracts management, through which he is heading and supervising the legal team of vetting the contracts and other legal documents, including CDA, service agreements, term sheets, software license agreements, MOUs, notices, etc. Today, being in a respectable position, he is here to give a session on intellectual property rights and patent procedure. I sincerely hope this session will make you more aware of legal compliance and helpful for future proceedings. Thank you and happy learning.
Thank you. Thanks for introduction.
Thank you, Dikshita. Now I invite and welcome Ravi Sam sir to give your valuable session.
Oh, thank you, sir. Thank you, Dr. PRK and Dikshita for a great and warm introduction. And so let me open my screen. So I feel like my screen is visible to all of you.
Yes, sir. Yes, sir. It is visible, sir.
Okay.
Okay.
So thank you. And let me go further. So as Dikshita introduced me, I don't want to again brief about myself. So just for the sake, right now I am heading IPR and legal team at Jubilant Biosys Bangalore. Coming to intellectual property rights, intellectual property itself is a creation of brain. So there are different varieties of intellectual property rights and elements associated with this intellectual property. So what is actually intellectual property? What is actually intellectual property law? And what is intellectual property management? And what is intellectual property rights? Let's briefly understand what are these words. So the intellectual property is the creation of mind. As you say, mostly these are related to inventions or literary and artistic works, sometimes symbols, logos, images, designs, mostly used in commerce. So intellectual property mostly related to business. So where you want to gain the business, the intellectual property is the important thing. It is more or less, I can say, it is more or less same as other properties. Rather, the other properties you can buy using with money, where the intellectual property is something like that which is generated in your brain. Intellectual property rights is the term which is used for the rights that are the legal rights, I can say, the legal rights which are secured by the state. Maybe it's federal government or union government in different countries, we can call it as. So the intellectual property rights are the legal rights secured by the government for the inventors or the people who create this intellectual property. So please try to understand intellectual property is the value of the value of your creation, where the right is a protection given by the government for your valuable creation. Now, the intellectual property management is something like that. And what is when we are working in an industry, whatever the industry it is, there is a pharmaceutical industry or software industry or integrated circuits industry, whatever the kind of industry you take, even in research activities, research and development labs, wherever it is, when the intellectual property is generated by the scientific staff, how to protect that? What is the procedure that we have to use? What are the different protocols that we have? How we can protect our intellectual property, our brainchilds in a proper way to get the security from the government, to oppose our competitors in the market. So for that to manage, a department will be created, which is known as intellectual property department. That property, the function of that property is called intellectual property management. I can say that I am one of the part of intellectual property management in the group of my departments, so that you can understand, I mean, what is actually this management is. Management is to protect and to cater the services of intellectual property wherever is required. So if we see elements of intellectual property, intellectual property particularly, so there are different kinds of intellectual properties. It can be a geographical indication, or a copyright, or a trademark, or a patent, or a design, or a trade secret like confidential information, or plant breeders' rights, or integrated circuits, layouts, or passing off. Passing off means generally how we technology transfer, I can say. How do we do the technology transfer? So these are all these are all the brainchild children of the innovator or innovative people in a innovative thinkers in the company or in an industry. So these are the different elements of the intellectual property rights. So intellectual property elements. So in this particularly, if you say, I mean, what is actually the major thing is right now today we are more discussing about patents. So because your management has given me a time of 90 minutes, I believe, right? Or 60 minutes. I think it is 1.5 hours, right? So in the 1.5 hours, the first maybe 30 or 35 minutes or max 40 minutes, I will briefly discuss about these different elements of intellectual property. And later for 30 minutes or 35 minutes, we will seriously look into the patents concept and how the patent is protected, because understanding of the patent is very, very important for you guys who are in the technical field, whether it is in the pharmaceutical industry or in the software industry, whatever it is. So let's go to different elements of the industry. Before going to the studying or understanding the elements of the industry, what is the benefit of intellectual property? Why do we protect intellectual property? So this boosts the business growth, obviously, because the moment once you have an intellectual property with you, I can say simply that you have the capability of doing something. That itself is an intellectual property. The management of that intellectual property obviously should give a business growth in your industry. In the same way, it should ease the marketing procedure, how best you can market your procedure, whether you can disclose your concept or not to the public, on what grounds can you disclose or what grounds you can't disclose. So but yes, you can disclose. So in this case, I mean, how best intellectual property is helping us. In the same way, how it boosts the export business opportunities in different industries. Nowadays, there is no domestic business or international business, something like that. Nowadays, it is entire industry is an international industry. I can say there is a pharmaceutical or software or simple small water producing, mineral water producing a simple shop, to a big software industry or a pharmaceutical industry or multinational oriented industries. So how best we can export our goods or our procedures or our ideas to other countries. So it boosts the business opportunities in other countries, and it convert. And also the major thing is this intellectual property gives you a confidence, which is giving you an idea, or which is giving you a pathway for converting your creative ideas into a profit-making asset. It's not only important that you have very good knowledge. It's not only important that you are very intelligent, but that should be presented, that should be disclosed to the public, or that should be protected in the same way. So this can be achieved by intellectual property. And then obviously the moment when your business is growing and your intellectual property is getting protected, obviously your finances of your business will grow up, and you will have a robust IP protection in your families and clients when you are working with different clients with your services or goods, whatever it is. So it will give a protection. It will give the protection to your goods, and it will give the protection to your when you are supplying it to your clients, the clients' goods, and also families. How the families or clients are also affected, we will see in the coming slides. So let me brief you on 1 or 2 points. What is actually the benefit of industry is that it is to stimulate your technological process for the benefit of the society, obviously. And owners of the intellectual property enjoy the monopoly profits. And there is a technological diffusion through licensing and selling, which is mostly I'm calling it as tech transfer. And of course, it contributes for economic growth of your industry, or obviously, end of the day, it is for the nation growth. So these are the major benefits of the intellectual property and intellectual property management. Let us see one by one now, because I discussed about a few intellectual property elements. I discussed like copyrights, patents, trademarks, geographical indications. All these things I have just shown you some slides. Let us see individually, when 1 or 2 slides. Let us understand what are actually these different forms of different elements of intellectual property. Let us look into the first copyright. What is a copyright actually? A copyright is generally given to a form of an idea or the information that is substantive and discrete. So the requirement itself is, the statement itself is saying that should be substantive and discrete. Substantive means it should have some stuff. Don't think that all whatever the nonsense coming into my brain, I can copyright it. No, I can't. There are that should be having some stuff, and it should be discrete from the already existing whatever you call, whether it is information or idea or a software or whatever it is. So I am saying here, these are the logos generally you must have seen in certain plays or movies or something like software. Even software carrying devices or something like that. This C stands for copyrights. and mostly these copyrights are in our present day scenario mostly related to the software. So how best the software protected in India is through copyrights only. I will discuss more why I'm writing specifically here in a box copyright protection of software and copyright notice, why it is important. Just note to understand why it is coming under copyrights, why not under patents. That also I will discuss. Now coming to the copyrightable work. What is copyrightable work? What can be copyrightable? What is copyrightable? What is not? What you can't do copyright. So if you see, the copyright is applicable to a wide range of creative works, including literary work and then artistic work, a poem, a thesis, a play, or other literary works, or movies, dances, musical compositions, recordings, audio recordings, I mean songs, music albums, paintings, drawings, sculptures, photographs, even photography. You don't surprise if I say some time back, when there was some time back means, I mean, a long back, maybe I was in somewhere in I was studying my post graduation, something like that. There was a crisis in Sudan. And this, in that, there one guy who is just passing through, a journalist who is passing through, has taken a picture, and in that picture, it is captured by just as a part of his job, he has taken a picture. The picture is in that picture, it is there like a vulture is standing there, and a dead body, not even a dead body, actually a baby who is dying because of hunger. And a vulture is just looking at that and that baby who is dying. Just let him die, I will eat him. So this kind of, it's a photograph, a simple photograph, but it is representing the entire nation's status at the time. So this is a copyrightable work. It has got so many applauses, but of course it is not something to enjoy. The situation is not, or the scenario is not something enjoyable, but still this kind of work, which is having some stuff, that kind of works come under these copyrights. Of course, radio and television shows, broadcasts, even your, sometimes even if you take photographs in your mobiles, cameras, or something like that, if it is really good and making some sense, you can take a copyright on that, publish it, but it should have some stuff. Don't think that whatever coming in before you and take the picture and publish, there's no use at all. So coming to the term of the copyright, so how long a copyright owner of the copyrights enjoy his right? How long? Is it for the lifetime, or there is some limitation? Yes, there is some limitation. In most of the world, in the entire world, you can say there are 50 to 70 years fixed period of time after the death of the author, or after the death of the owner of the copyright. For example, a photograph of a good value can be utilized. Cannot be utilized by anybody, first of all, just like that. So when we can use it, only after 50 or 70 years his post-mortem. That means after his death, 50 to 70 years. The mostly followed throughout the world, the mostly followed convention is the Berne Convention. The Berne Convention, made in Germany at the time, in somewhere in 1930 or 1940, that makes a requirement that at least 50 years post-mortem term is required for copyrights. In India, I can say in India it is 60 years period of time is considered as a copyrightable term following the death of the author or the owner of the copyright. So let us see. So that's about copyrights. So now I can just give you a small understanding. I just recall you the copyrightable work, mostly literary, dramatic, musical, software kind of work. Now, what is the trademark? So you will have to understand. You should be in a position to what I say, find out the resolution between these different kind of components. Don't confuse a copyrightable work under trademark, a trademark work under patentable. No. Copyright should be protected under copyrightable works should be protected under copyrights only, and trademarks should be protected under Trademark Act only. Let us understand what is coming under trademarks. So if I read my statement here, a trademark is identified by two symbols. You must have seen this TM or R, something like that in some of your goods. Some of your goods or whatever you are purchasing, somewhere you must have seen that TM or R. So this is related to the trademark. Whether sometimes this trademark is registered or sometimes is the trademark is not registered. Whether it is registered or not registered, a trademark is trademark. So it is a distinctive sign or indicator used by individuals or companies or legal entities, whatever it is, for their products or services to the consumers, for understanding the uniqueness of the product. For example, I can say if a strip of tablets where Dr. Reddy's is mentioned, the Dr. Reddy's, that symbol is there, that's what makes the trademark. And there are, say, some 3 or 4 companies. Dr. Reddy's is available, Ranbaxy is available, and Cipla is available, and then some other companies are available. They will say, which one do you select? So maybe if it is generic subgo, of course, anything you can take, but the time if you know something like that, or if you have confidence on particular Dr. Reddy's or Cipla or Ranbaxy or some Pfizer or any other company, you can buy that. So that is what is the trademark, which is giving you a differentiation. Okay. Now coming to some trademarks which are registered trademarks, what I have written here, that Yahoo, Adidas, or American Express Mobile, Puma, Pepsi, Cola, all these things are registered trademarks. So mostly when I say it is TM, if you look a mark like TM, it is an unregistered trademark. What is this registered trademark and what is this unregistered trademark? If it is marked by R, that is a registered trademark. If it is marked by TM, it is an unregistered trademark. Patent of Indian Patents and Trademarks Office, IPTO, what we call it as. In that place, we'll have to go and register this particular logo as a trademark for our company. Then it is called registered trademark. If you don't register, also no problem. In such a case, it is a non-registered trademark. But what is the disadvantage? I will explain you. Yeah, what is this? Any boys can tell me?
Sir, their mics were disabled. If anybody want to talk, you can just raise your hand. I am going to unmute you. Anybody want to interact with this, sir? Just raise your hand. I'm going to unmute you.
Because see, I like the boys to interact with me while I am communicating with you, so that let's make it as an interactive session. Otherwise it looks boring. So let me understand. See, this is a logo which is generated by your company, NRI Institute. So my first question to you is this logo or is this trademark, is it registered or not? You can find out. If it is registered, what is the advantage? If it is not registered, what is the disadvantage? That's if we see a registered trademark is something like that. First of all, I'm telling you, registration is not required for a trademark, but still why people are registering? Because it gives you a protection if somebody infringes your trademark. See the same logo, because your NRI College of Institute, I know from past, I think some 10 or 9 years, because of the presence of one of my students, Mr. Surendra, NV Surendra. He was my student some 2 decades back, and he was your placement officer somewhere, something he's working. So I know him in your college. So I know this college he has got great reputation in the technological studies and engineering colleges and all. So having said that, if I use this same logo, because you are sitting in Vijayawada and nearby places in Andhra Pradesh, let me sitting in Bangalore. If I start the same logo with the same logo, if I start a college in the same way, so that I will make use of all your credentials, because you have got a very good laboratories, you have got a very good placement cell, you have got a very good staff. So you have so many positives or advantages in your college. I will add all those things. This NRI, I will just start a college with the NRI here. Is it possible? It is not possible unless you oppose it, because I am using your trademark. That is, and when you can do that, if it is a registered trademark, you can approach the court and any jurisdictional body saying that Ravi is infringing or stealing my logo and using or making advantages, profits. Sorry, making profits by using my logo or my credentials or my whatever it is, my reputation, something like that. When you don't have the registered trademark, you cannot approach the legal, or the legal cannot give you the protection. It is only that you have to prove to the public that, see, this Ravi guy who is using this particular my logo without having my approval, and I am nowhere concerned this. Understood my point? So end of the day, when it is registered, the jurisdictional body will give you or will protect you from infringing your trademark or your services. If you are unregistered, this responsibility is on you to show the public that this guy is infringing your services or your reputation. So that is the difference between a registered trademark and an unregistered trademark. I hope I am clear. So I'm moving ahead. So I can say briefly, I can say in 2 or 3 lines, a trademark is typically a name, a word, a phrase.
Sorry.
I'm sorry.
Sir, no issue, sir. Please continue, sir.
Yeah, a trademark is typically.
Sir, somebody, some of the students want to interact with you.
Yes,
Ravi,
please.
sir, please continue, sir. No issues.
20,369, you can talk.
Sir, Ravi, sir, please continue, sir. No issues.
Yeah. Okay.
Sir.
Okay, I will give you. I think I will stop after 10-15 minutes. Then we can interact for some time. So coming to a brief on trademarks, I am saying that trademark is typically a name, word, phrase, logo, symbol, design, whatever you call it as, image, combination of these elements. I can say Dr. Reddy's DRF or DRL, something like that. This is a combination of elements. This is a combination of letters, something like the NRI. There must be some kind of definition. I don't know, but NRI must be some definition. Must be some words or something like that will be associated with it. So this is a trademark. So the characteristic feature of this trademark, this characteristic feature should be distinctive and it should not be deceptive. See, just like saying NRI is a college which is having very good reputation, I cannot make NRII. It is actually deceptive. I am actually making a deceptive logo with you. Same NRI, whatever your logo is there, I'll put one more I next to NRI and I'll use my logo. That is not acceptable, because this is deceptive on the original NRI logo. In the same way, so whatever it is a DRF, DRL, Dr. Reddy's or Satyam Computers, of course it is not. Let's not talk about Satyam Computer, TCS or Microsoft or whatever it is. If I change Microsoft, if I say Microhard, it is again deceptive. Saying Microsoft and Microhard, if I say Microhard is a company like associated with Microsoft, no, this is deceptive name. So this kind of things cannot be chosen as trademarks. So one advantage of this trademark is, of course, the disadvantage also, that registration is not required. So how it is advantages and how it is disadvantages, I have already told you. In case of your logo, if I use in a wrong way, if I infringe your logo in a wrong way. So I think you must have understood what is the advantage of registration and what is the disadvantage of not registering the trademark. But the law doesn't force you or doesn't provide you to give to follow a registration process. It's up to you to decide a registration is required or not. But copyrights is not like that. Copyright should be registered, or patent should be registered. Geographical indication should be registered. In the same way, trademark, there is no compulsory for registration, but it is suggestible. As an IP head or as an IP man, I can say it is always better to register. Now, another advantage of trademark is patents or copyrights or any other intellectual property element, if they expire after a period of time, where trademark never expires. Trademark cannot be expired. So nobody else in this world can use trademark even after so many years also. Even your college name or your college logo or your whatever it is, your trademark cannot be used by or should not be used by anyone else unless they have a malintention of what you call affecting your reputation or make use of your reputation, whatever it is. I can use the best word of make use of your reputation. Now coming to my next slide. Now let us see what are these trade secrets actually. What are the trade secrets? Trademarks and trademarks are completely open kind of things. Then trade secrets, there are so many other forms of trade secrets. It can be an instrument, it can be an advantage, it can be a privacy or a confidential data or a formula or a process or a business or an investment or a knowledge, whatever it is. As long as you keep it secret in your company to run the show, that is regarded as a trade secret. It is, as the name suggests, the trade secret you cannot go for as long as it is. See, just simple word I am saying, a secret is a secret unless it is open, right? So you cannot keep it as in the public domain for saying, yes, this is my trade secret. You cannot show this is my trade secret. You cannot show the formula, this is my trade secret. You cannot show your investment, this is my trade secret. So trade secret is a secret until it remains secret. This can be understood in a better way in the coming slide. Let me tell you what comes under trade secret. So the trade secret, as I told you before, these are all designs, instruments, patterns, formulas, all these things will come under this. And this is also known as confidential information. And the lack of formal protection, there is no formal protection for this. You don't, generally trade secret cannot be protected by law. But as a confidential information, as on the grounds of breach of confidential information, in a general legal terms, secrets are protected. For example, I shared a confidential information with you, say a tablet preparation. A tablet preparation I am doing. I want you to manufacture that. I share that confidential information to you. That is a trade secret. You cannot disclose it to others. At the same time, I can say, if the moment if I have given in a public notice that this is my formula, everybody can do that. There is no more it is called a trade secret. So in the same way, one best example is Coca-Cola example. Coca-Cola formula, not only Coca-Cola or Pepsi-Cola, whatever it is, if you say, what is this Coca-Cola formula? The flavor, see, the taste and flavor are different. Most of these beverages, these soft drink beverages, whether it is Coke or Coca-Cola, Pepsi, or what, these are all sweet. Taste is same. What it makes difference is the flavor. The flavor is because of the formula. So this formula is a secret. This formula cannot be disclosed to anybody. So the Coke, the Coca-Cola, whatever juice or a drink, what you are drinking, you know that it is taste, sweet is there, carbohydrates are there, and a flavor is there. But what is there in the flavor? That is what is secret. In Coca-Cola, I am telling you, in Coca-Cola, only 3 people know the formula. The chairman of the company and the technical head of the company and manufacturing head of the company. These 3 people only know the formula of the company. They will come, they will mix all the formula, all the ingredients, and give the entire substance to the further people for further manufacturing. Nobody can reverse engineer, nobody can find out whatever this is. And also this secret is maintained so much so much confidentially and so much aggressively, like these 3 people cannot sit in a room. These 3 people cannot travel in a car. These 3 people cannot fly in a flight, because the moment if the flight blasts, entire formula is gone. These 3 people cannot sit in the same meeting. If the blast happens in that meeting, all of the people dead. No problem, no issue. The formula itself is lost. So that is the importance of trade secret. Most of the trade secrets are related to these kind of formulas only. But I'm telling you, particularly in software industry or pharmaceutical industry, this kind of secrets are protected in the form of confidential information. Confidential information can be a letter or a document, whatever it is. But formula is different. Moving ahead to the next one, that is industrial designs. Industrial designs, I can show you. There are different kinds of chairs here. There are different kinds of computers here. Nowadays, these bands, you can say the watch bands. How many bands we are seeing nowadays? I think now in this class there are 120 students are sitting. I am sure that at least there are wearing some 100 to 120 different varieties of these hand bands or watches. So this kind of bands, and each one may not resemble the other one. This is because the design is different. In the same way, you can see the chairs, the easy chairs, the sitting chairs, handrest chairs. There are so many different kinds of chairs. Raj Kamal, Neel Kamal. These are different kinds of design chairs and design chairs. In the same way, computers, different forms of computer. Nowadays, you can find out different forms of computers with keyboard, without keyboard, with so many other features you can find. Of course, motorbikes, I don't need to tell you, engineering boys, you yourself know hundreds of motorbikes, designs of 100 types or 100 varieties of motorbikes. In the same way, in the cars also, there are so many aerodynamic, and then I don't know. I mean, I don't know the names of the designs. That many kind of car designs are available. So they're all forming an industrial design. This design is an intellectual property again. So some people may like one design, some people may like other design. That is a different concept. But as long as your design, your intellectual creation of your design is valid and people are accepting that, you are making money. That's what at the end of the day, intellectual property. What is the use of intellectual property? Is creating wealth. Intellectual property is nothing but creating wealth. Any other property, you want to buy a house, you want to buy a car, you have to spend the money. Where if you have the intellectual property, you will generate the money. That's the difference. That's the beauty of the intellectual property. Now coming to the major abstract theories, an industrial design or sometimes intellectual design or industrial design or simply design is an ornamental or aesthetic design. It may be a three-dimensional structure sometimes, or a two-dimensional pattern, or different colors, or different logos, different lines, patterns, colors also important. Sometimes even sounds also. Ting, ting, ting. You must have heard about this song somewhere in Nokia phone or Airtel. I don't know what is that, but that kind of sound, that is an industrial design. So this kind of patterns which are protected and which indicates the particular company is making this kind of design or this kind of product. That is the importance of intellectual property, industrial design. So that industrial designs can be applicable to various industries. I can say even from big industries like motors, automobiles, and then to small industries like handicrafts. Where not? It is in watches, it is in jewelry and fashion designs, of course, luxury items. Of course, there are so many houseware furnitures, electrical appliances. These are all things are coming under industrial designs only. Even furnitures, even beds, cots, tables, all these things are coming as these different designs. So of course you can see in telephones, of course in telephones, if you say mobile phones and all, how many designs of mobile phones you are using nowadays? How many designs of computers you are using nowadays? Airplanes also, see the difference between the Indian Airlines flights and Indigo flights in India. I am not talking about the British Airways or other United States Airways. Just look at Indian. You find the similarity of all Indigo flights. You find the similarity of all Indian Airlines or Jet Airways. All these kind of things. These are also designs. And then of course cameras. Nowadays nobody is using cameras because they are inbuilt in mobiles. And of course watches, as I told you, different kinds of bands, watches. These are all designs which are making you money. If your design is good, you are think that you are there forever in this business. So that is about the industrial design, I can say. Now coming to geographical indications which include I have listed some of the geographical indications here. The buffalo which I am looking is I have taken the examples from your nearby places only. This buffalo is a what is that? Ongol buffalo, and these are Nujweed mangoes. Of course, everybody knows and everybody likes the Tirupati laddus. And don't look at that girl. That bride is already waiting for her bridegroom. She is wearing Kanchipuram saris. So Kanchipuram saris is a geographical indication, and Hyderabad biryani is a geographical indication, and Kondapalli toys, these are geographical indications. These are all geographical indications which are having importance of that place. These are originated from that place. Ongol, from Ongol, the buffaloes, Ongol buffaloes are very, very potential in giving milk, in milk yielding, and tolerating hard conditions, extreme hard conditions. In the same way, Nujweed mangoes are having the stuff of good juice and having fruit value. Of course, Tirupati laddus, I don't need to say anybody who has born here and in India, and that has got the different taste, and that has got the aesthetic values, sacred values, so many things, sacred values, and all are associated with these things. And of course, most of the silk sarees, Kanchipuram silk sarees, there are we know many silk sarees, but most of us know Kanchipuram silk sarees. Why? Because the quality that maintains. We know many types of biryanis throughout India, but either Hyderabad biryani has got some of its speciality or some of its taste difference. And also in this kind of Kondapalli toys, this kind of dancing toys and all, they have that credibility to that local area. So based on these, geographical indications are characterized. And if you see, a geographical indication is a name, sign, or different kinds of products which are associated with that location or origin, maybe a town or region or a country, whoever it is. So this geographical indication, you have to go and register based on your quality, your reputation, your quantity, and how many people are using, how many people are enjoying your product. So based on these parameters, you will have to go to the registered office, geographical patent and trademarks office, and register the geographical indication over there. So I have mentioned the same names here: Ongol, plus Nujweed, mangoes, Paris perfumes, French beer, Kentucky fried chicken, Kentucky, what is that? KFC, Kentucky fried chicken, something like that. So these are all geographical indications. This indicates the quality of, or the, what you call, the not employability, I can say the skill of the people who are staying in that area, or who are doing that kind of services. So that skill is what is the intellectual property here. Yes. Now coming to patents, just before coming to patents, what is my time now? 2:45. I'll just give a small 4 minutes or 5 minutes break to you, so that, not break actually, I will just give you to talk if any doubts are there on this, because we'll go a little more deeper into the patents thing. Yes, sir, Dr. Vijay or Dr. PRK, yes, someone are there, you can allow them to speak. Excuse me.
Yes, audience, you can talk now. You are given permission to unmute your mics. If anybody want to interact with this, sir, you can interact.
So no one? Okay, no problem. You can talk to me, or you can write to me anytime to my email or something like that. If you have any doubts anytime. So I'm going back to the presentation. Yeah. Once again, I'm asking, is my screen visible?
Yes, sir.
Great. So can you make it out something? Who is this guy? Voice? Michael Jackson?
Michael
You must
Jackson.
have heard about his great album, Dangerous. So you see that the guy Michael Jackson, who is wearing that white hat, he's almost leaning in a straight line for almost, I can say, 60 degrees. Is it possible? Is it possible for a general standing person? So I mean, without having any what do you call, support or something like that, it is not possible for a person to lean like that for 60 degrees or something like that. So he actually designed or he actually invented a kind of shoes which are allowing him to lean like that. So he got a patent on that. I mentioned here the patent number 5245452. I think you can even download this patent. Go to Google and download this Michael Jackson's patent. You will get this patent. You read out this patent, you can understand how he's using those shoes, or how he designed the shoes, so that allows you to lean without falling on the floor for about 60 degrees. So why I am putting this is, this is not a design, but this is an invention. This is coming under a patent. That's, you have to understand. This is not a design. This is not a shoe design. This is a patent. This is an invention. There is an invention behind that. So this is called Michael Jackson patent, which has got very popularity during that time. Maybe, I mean, this Michael Jackson, I don't know how many of you know. Most of you know, from my understanding, but most of the people of our age are very fans to that, because he He was very popular during our education days, college days and all. Anyways, I'm moving to the next one. Now coming to what are actually patents, and if you see, a patent is a set of exclusive rights granted by the state. As I told you before, the patent rights are granted by the government to the inventor for his assignee for a limited period of time in exchange of disclosure of an invention. So for example, I am taking a small example. I have designed a tablet. I have designed a tablet, or I have invented a tablet, and my company is taken my intellectual property and filed a patent. So what is the advantage I get as an inventor? What is the advantage my company gets as an assignee? So don't confuse between these two words, inventor and assignee. Inventor is the person who is actually putting his brain, where assignee is the person, mostly it is funding. It's a funding agency. For example, a company is funding for me to research something, and if I come out of the invention, then I am the inventor. I am the founder of the, or I am the inventor of the that invention, or I am the first person to invent that invention. But the invention belongs to the company because they funded that. So there is an agreement between me and my company saying whatever I am inventing here, whatever I am inventing in your lab with your funding shall belong to you. So the company can make the money. That is understanding between the scientists and the companies. Now you must have understood most of the inventors in this world, I can say, or in India or in anywhere it is, most of the inventors are less what you call, I can say, are less prevailed in the society, just because the company is taking over the invention. The company is taking over it as having a contractual obligation with the company, because the individual person, as a person, I cannot establish that much big R&D society, R&D labs, instruments, all these things. So the company is investing that. In return of that, they are asking me to assign my intellectual capability to them, and they are paying me salary. So I am the inventor and the company is the assignee. So whatever it is, sometimes it is also possible. Sometimes it is also possible that an inventor, without going to any assignee, he can find out, or he can file a patent. For example, in your college or any other college, one of the college professor, I know, he has come with a small vaccine kind of thing during his laboratory, just in his laboratory, not even using the college funds or something like that. Excuse me. During COVID season. So he came to me and asking whether I can file a patent. Why not? Yes. But because you are working in a college or in an organization, you take his approval, saying that yes, this invention is coming out of my funding or something like that. This invention completely belongs to the scientist. So yes, the inventor directly can file a patent. No need of company is involving, organization is involving, or an assignee involving. So what is the patentability criteria? I will come next. Then a patent must include one or more than one claim. So what are claims actually? See, the invention can be anything. I am coming with a tablet. What is actually the invention? Tablet is not new. Tablet is known to the world from years and years. So what is actually new in that? Is the active ingredient, or is it an excipient, or is it a method of use? What is actually is making the stuff? What is actually the invention? So that invention is clearly written. This is my invention in making this tablet. That is called claim. So each and every patent should contain at least a claim or more than one claims. So unless a claim is there, you cannot file a patent. And coming to the procedures for filing and granting these patents vary from country to country. And the patents can be electrical, biological, chemical, or even software patents, not in India, but in US. In US, software is not a copyrightable product. Software is a patentable invention in US, where in India, software is copyrightable, not patentable. In the same way, chemical, of course, chemistry, all chemical and biological materials which are artificially produced, biological material are all protected by patents. And of course, as I told you before, software is patentable in India, but not in, patentable in US, but not in India. And how long you will get the protection for a patent? A patent is protected, or end of the day, the invention is protected 20 years from the date of filing. So today I filed the patent. From today, July, I can say 19th, July 19th, 2022 to 20 years means 32, 42. July 42 till July 42. If I file my patent application today, my invention will be protected for a period of 20 years. In these 20 years, I can do whatever I can earn whatever the money I can make. These pharmaceutical companies are making millions, billions of dollars based on this only. Billions of dollars based on this only. These are innovative drugs. But of course, in India, innovative companies are less, mostly generic drugs. That is a different discussion. Leave it. But most of the pharmaceutical companies, when they are coming with a new tablet and take a tablet or injection, whatever it is, whether injection or a suspension or a suppository, whatever the dosage form it is, if they file a patent, they will get 20 years of monopoly. Nobody other than that company can sell that product, can make that product, can offer that product, can even disclose that product, can even do research on that product. So that kind of protection the government gives. That is the reason, as I told you, these pharmaceutical companies are making millions or billions of dollars. In US, if you see here, I mean, I don't know, each product itself, each tablet or each suspension or each injection itself, it's business. The US in regulatory market, if you in billions of dollars. Sometimes I surprised to see that these people in US, they eat food or tablets. So in that way, I mean, this is the capability. So what my intention is to tell you that this is the capability of your brain. A company is making billions of dollars on a tablet means, where is it coming from? It is coming just from a boy's brain, just like you. A boy like you, it is coming out of the brain of a boy like you. And a company is making millions or billions of dollars on this company, and the company is surviving on this business. You must have heard about a company called Genentech. Genentech is a biological industry, biosimilar industry, which produces recombinant erythropoietin, which is used for cancer, anti-cancer oncology drug, erythropoietin injection. That injection, that company is surviving from the past 15 or 20 years because of the patent is held by them. And the surprise, if you see, if I say you will surprise, the inventive concept came from the intern of a college. This boy is just 18 years boy who completed his B pharmacy course. I don't know what it is called in B pharmacy in the US, but a pharmacy graduate, after his completion of graduate, he went to that college. He went to that company called Genentech and did some experiment. He resulted end of the day, end of some 30 days or 45 days duration will be there in internship. In that internship, he prepared a protein called erythropoietin, which is exactly similar to the human erythropoietin. For leukemia drug, human erythropoietin is a very good drug. Immediately, the company filed the patent. This boy is rewarded with some thousands or I don't know, some millions of dollars, I think, because US companies are at least having good ethics. So they have given some, but at survival. But if you see that survival of the company with 1,500 employees, starting from 1,500 employees, today that company is as big as 40,000 employees. The company is surviving on this product only. And this is the brainchild of one boy who is out of college from a pharmacy graduate. I can understand. I think in my group now, in your group now, there are about 130 boys are there. How many billions of dollars we can make it out? Forget about that. Now coming to what is the advantage of the patentee? A patentee enjoys the exclusive might. So when the patent is filed, what is the right? What kind of right you will get? I am categorizing that you can make the patent, you can make the product, you can use the product, you can offer for sale, you can sell the product, or you can import the product, or you can export the product. All these kind of rights are given to you as a patentee, as the owner of a patentee. A patented invention becomes free for use in the public after the expiry of the term. That's I already told you 20 years from the date of filing. After 20 years, patent term expires. After that, the same formula can be after genetic patent expires, erythropoietin. See that now that erythropoietin injection vial itself is 20,000 rupees, man. 20,000 rupees if you want to get that injection. One injection, 20,000 rupees. And that injection value, once the patent expiry, once patent expires, the value of the 20,000 rupees will come to some 500 rupees or 600 rupees. Just because so many generic companies will come. Because the patent is no more, no one will stop. Legal will not stop you. Jurisdictional body will not stop you. Patent is expired. Anybody can make use of the patent. This is the disadvantage of the patent in one way, and the advantage is that the moment when you are filing a patent, you are showing this is my invention. This is my invention. In this recombinant DNA, this is the product. This is the API, or API means active pharmaceutical ingredient. These are the components I use. These are the excipients I use. This is the solution I use. This is the buffer I use. I prepare it like this. This is the temperature I maintain. All these things is completely disclosed to public. Advantage is that no one will work on that. Another person can concentrate on another. It's already disclosed. Don't reinvent the wheel. It is already done. Don't reinvent the wheel. So other person will concentrate on. This is the advantage, and the disadvantage is the owner of this patent will enjoy this monopoly throughout the world or throughout the country in that 20 years duration only. After that, anybody can make use of this. This is the difference between trade secret and patent. Where in trade secret you will not disclose it to public. That is the reason you have to maintain it hundreds of years like that only. That is the reason the stringent rules are there. All the three people should not sit in one room. All the three people should not travel in one flight. This kind of things are not there in patents because it is already there. Even just for fun also you can make at your home, but you cannot sell it. You cannot sell it. You cannot make any kind of commercial benefits over that. That is the patent concept. Now coming to the next concept, the objective of patent legislation is to encourage inventions of new and useful manufacturers, to induce inventors to disclose the secret of their invention. I am disclosing as an inventor, I am disclosing you. This is my secret of the invention. So you don't make it. You make other one. Let me enjoy that. Let me enjoy my invention for these 20 years. So that is the objective of patents. Now, patentability criteria. What can be patented? What cannot be patented? So there are three important criterion rules for a invention to be patentable. The first one is novelty. Novelty means it should be new. It should be very first time disclosed, very first time identified, something like. I cannot say it is discovered. Discovery is not patented. It's not patentable. So let us see why discovery is not patentable. Let us see that. So, but novelty is something like a newness, fresh, first time in invention. Non-obviousness. Non-obviousness means a person who is skilled in the art. You are engineering guys. You know something about, I don't know. I mean, because I am not an engineering guy, I cannot use, all scientific words like you. I'm just giving you an example. Integrated circuits. Most of these people who are working on integrated circuits know about integrated circuits. Even I also know about integrated circuit, but I am not a person skilled in the art, but you are a person skilled in the art. In the same way, a tablet formula or an injection formula, I am a person who is skilled in the art, but you are not the person who is skilled in the art. Non-obviousness is something a person who is skilled in the art should be able to tell by looking at the formula or looking at the integrated circuit. Yes, this invention has got some stuff. If someone comes to me with a tablet formula, having knowledge in that, if I feel that there is some kind of stuff in this, yes, that is called non-obviousness. It is not easily just like that. I cannot, it will not come just like that. There is a brain power. There is a lot of thinking, lot of hard work is there. All these kind of things I only know because I am skilled in the art. In the same way, in your engineering subject or whatever it is, I'm not very well versed with it, so I don't use much words of that. So whatever it is, whether it's electrical circuits or whatever it is, a simple bulb, I can say. A simple bulb is a bulb for me simply. I can say because I don't know. It is giving good glow or bad glow. That is only I know. But what is actually there inside, that the electrical boy knows well. So if he feels, if I come to that boy with this is my formula, or this is my discovery or my invention in this, if you feel says yes, This has got something. It will not be achieved as simply as that. This has involved lots of hard work, lots of energy, lots of what you call mental agony, all these things. Then only it is having some stuff. So that is called non-obviousness. And then the third requirement is the industrial applicability. Industrial applicability means that it should be produced, or it can be produced, which is having the use. It has applicability means I can say industrial use. It should have industrial use. Previously, in most of the cases, utility is a word they used to use utility, but that utility word is removed and industrial applicability is made. Why? Why? Because this is a funny incident in India. That guy, not that guy, that lady, one lady, she has found a knife. She found a knife, and the knife is having very good hold. It is having some novelty, and people felt that's something a non-obviousness. But it is used for only cutting vegetables or cutting the head of her whatever whatever her mother-in-law or something like that. So it doesn't have any industrial applicability, but it is having her in her thought process. It is having her use, but it is not useful for anybody except her. So that kind of invention is not what you call patentable at all. Industrial applicability means it should be commercialized. It should be it should be sold to different people for their use. So these are the three things should be matched. One is novelty, non-obviousness, and industrial applicability. These three concepts should be there. These criteria should be there for your invention to get patent. Now coming to understand, it's a what is an invention actually? What is everything coming under earth is not an invention, right? So Section 2(1)(j) of Indian Patent Act defines invention as a new product or a process involving an inventive step. It should have inventive step. That's what is called non-obviousness and capable of industrial application. This is called utility or industrial applicability. It should be new. It should be having industrial applicability. It should be non-obviousness. That is what is in the definition. An invention is a new product or a process involving inventive step capable of industrial application. So all the three concepts are covered here. Now, if anybody comes to you or to me for an invention with an invention, whether it is patentable or not, first of all, I have to understand what are not patentable. As per the Patent Act 1970, what are not patentable? Very clearly, the Patent Act Indian Patent Act 1970 mentioned what are in the invention, though they are inventions, but they are not patentable. So these are specifically mentioned in Section 3 and Section 4 of Indian Patent Act 1970. Let us see what are not inventions. Though they are inventions, they are an invention, but they are not patentable. What I have written is wrong actually. What are not invention is correct usage. What are not patentable, or what inventions are not patentable? Non-patentable inventions. I can correct it as what are non-patentable inventions are. So inventions that are not patentable. Let us see. See this guy. What is this fellow is doing? This fellow is drinking some liquor and smoking and using all nonsense, doing all nonsense, using cards, all nonsense. But he's having an inventive idea in that. Is it having any use of that? What the section says? Section 3A says an invention which is frivolous or which claims anything obviously contrary to the well-established natural laws. Well-established, whatever he is doing, whether it is cards playing or drinking alcohol or whatever it is, these are all things are contrary to or obviously contrary to natural well-being, wellness or well-established natural laws. And further, this is a frivolous invention. This is a frivolous invention. Frivolous means of having no use at all. Useless inventions. This kind of inventions are not patentable. And then see, if you see an invention, which is the primary or intended or use of commercial exploitation of that invention, could be public, contrary to the public order or morality, or causes serious prejudice to human, animal, plant life or health, or plant health or environment. It causes any kind of serious harm to human life or animal life or plant life or health or environment. That is not patentable. Even though it is a new invention, Previously, during Corona season, COVID season, so many companies are coming with supplying oxygen cylinders. These oxygen cylinders cannot be patented just like that without having proper thorough checkup. Okay, if it is having any kind of carbon dioxide or carbon monoxide, the guy is gone. So these kind of things are not at all patentable, which are causing or which is causing serious harms to human. Just like previously, I have given an example. I prepared a knife to kill my enemy. It is having an invention. It is having novelty. It is having non-obviousness, but it is against the public order. It is against the morality. It is serious. It creates serious or it poses serious harm to the human life. This kind of inventions are not patentable. Then mere discovery. See, discovery, the word itself is not patentable, I am telling. Anything which is discovery means what? Existing, identifying the existing ones, right? So the mere discovery is not at all patentable. You can read out this, the mere discovery of a scientific principle or a formulation of an abstract theory or a discovery of a living thing or a non-living thing that is obviously occurring in the nature. That is what is called as discovery, no? It is not an invention. Invention is different and discovery is different. I found some stone in the somewhere in African forests, and the stone is giving some kind of use. And so the stone is rub the stone and apply that powder to a boil on your hand, and it is reducing. Where is invention in that? It is a simple discovery. So that kind of discoveries are not patentable. And the mere discovery of a new form of a substance which does not result in the enhancement of the known efficacy. This is a little point of discussion. See, for example, you must have studied chemistry during your graduation or pre-graduation, something like that. In graduation or pre-grad in your chemistry, you must have studied about polymorphic forms. That means a substance can exist in different forms. Right, carbon can exist as diamond, can exist as graphite, can exist as so many other varieties. Like a compound, as I previously told you, active pharmaceutical ingredient or API can exist in different polymorphic forms. It can be exist as a what you call hydrated form, anhydrous form, solvate form, alcoholic form, acetonic form, different forms. These all forms are, if you see physically, they are different. But unless this form is having no efficacy enhancement from the actual parent molecule, it is not considered for invention or it is not considered for patent. So this is what this section D is saying. The mere discovery of a new form of a substance which do not result in enhancement of known efficacy of that substance or the mere discovery of a new property or new use. This is also important. One more example here I'll give you. Viagra. Viagra is a tablet which is actually identified to reduce hypertension. But later, when Viagra is used by people for hypertension, BP, blood pressure reducing pill it was. After that, this pill shown to be is having on erectile dysfunction. It's a new use. Previously, it is for hypertension. Now it is for erectile dysfunction. So uses are different, but the compound is same. That is not patentable in India, but it is patentable in US. Please remember, use patent, different uses of the same product is not patent. Second use patent or second use at all, whether it is first use or second use, whatever it is, use you cannot patent in India, but you can patent it in US. So that is the difference between US law and Indian patent law. Here, the new use cannot be, or a use of the patent. Use patents are not there in India, but it is there in US. As simply as that. In the same way, new use of a known substance, machine, or apparatus, whatever it is, new use or use of a product is not patent. The product is patentable, but its use is not patentable in India. Where in US, the product is also patentable, use is also patentable. If it happens to find a second use, that is also patentable. So that is the difference between not only in US, actually it is use patents are accepted in US, Europe, Japan, China, all these regulatory markets. Non-regulatory markets, particularly in India, Canada, and some other countries, some Latin American countries, and some African countries, these are use patents are not, because most of these are developing countries. Now coming to the next one, this is I have already given this salts or ester, different kinds of polymorphic forms. This is already I have given, I have explained in the previous one. This is the same explanation. So a substance obtained by admixture resulting only in the aggregation of the properties of the components thereof for the process for producing such substance. I will explain it to you. I'll explain it to you in a small example. See, in this arrangement, if you see this train is going, this train is having two engines. Why two engines are there? Why not only one engine? Because the behind you say the tail of the train is a heavy material there, it is transporting, and one engine is not sufficient for that. That is the reason he added two engines. So these two engines, by adding two engines, this entire unit is bringing the more of load with it. Is it patentable? No, it is not. Where is the invention in that? See, for example, if I can say, if the tail I cut into two pieces, one can carry by one engine, another can carry by another engine. Here we are just joining this. So this kind of mere arrangement or rearrangement or duplication of known devices, and each functioning independently, and the end result will be sum of the two. Then there is no use of there is no invention at all. There is no brain at all. This is just like you are manipulating the things. You are making the things possible. That's it. Now coming to another example, I will tell you. I'm sorry. So this is done. Next one is invention which are related to atomic energy or nuclear explosions. Atomic bomb or nuclear bomb, an invention, any invention related to these atomic bombs or nuclear bombs are not at all patentable in India. Method of agriculture, method of horticulture are not patentable in India. Method of agriculture and horticulture are also not patentable. Method of agriculture, the products when you are using in agriculture and horticulture can be patented, but the method of agriculture is not patentable. There are different kinds of methods. Previously, they used to do the harvesting and all with using plow and all. Later, some tractors have come. Now harvesting machines have come. There are so many things developing. This is a method. These are all methods, but these are all not patentable. What is patentable? The lorry is patentable, the machine is patentable, but the method is not patentable. You understood the difference between the method and product. And another one is, even in medical field, the treatment, the medicinal or surgical treatment or curative treatment or diagnostic treatment or therapeutic treatment, treatments are not patentable. Medicines are patentable. Okay. See, for example, if you see the surgery, the eye surgery, different kinds of cataract surgery or something like that, laparoscopic surgery, whatever you call it as, these theories or these procedures, these treatments are not patentable. What are patentable? The instrument can be patented. The components or the medicines used during the surgery can be patented. Try to understand. Don't confuse between these things. The process is not patentable, but here the components or different products can be patentable, whether it is a medicine or an injection or even the guy is using some syringe to inject. That syringe is also patentable, but the procedure is not patentable. Now coming to the next one, artificially generated living forms by using recombinant DNA technology or some biological process. See, this is Dolly, the sheep which is produced by DNA rDNA plant. This is not a naturally produced sheep, but it is produced by artificial insemination, or you can call it as a test tube baby procedure. In that procedure, if this baby is produced, this baby sheep is produced, you cannot patent that. In the same way, a plant is produced by recombinant DNA protocols or following protocols or biological procedures. You cannot patent that invention at all. And apart from that, for example, another example I can give you, one example before going to the next one for your better understanding. See, paracetamol and ibuprofen. Paracetamol is a tablet which is used for high fever, which is used for fever, I can say. And ibuprofen is a tablet which is used for body aches, body pains, or pain and inflammation, this kind of things. If I prepare a tablet by mixing these two, ibuprofen and this one, paracetamol, it is not patentable. Combiflam is same. Combiflam is ibuprofen and paracetamol. Effectively, it is used by the people who are suffering from body pains and fever. So instead of taking 2 tablets, one has paracetamol and one is ibuprofen, he is taking Combiflam, which is having both the tablets and the same thing. There is no great engineering in that, or there is no rocket science in that. As simple as that. Apart from that, a mathematical or business model, a computer program is not patentable. Just this slide you follow a little carefully. Literary, dramatic, musical work is not patentable. Telephone production, television production, cinematography, music, artistic work. And the same thing, the method of performing a mental act, a method of playing a game, this is not patentable. Presentation of information is not patentable. Topography of integrated circuits is not patentable. Why I am saying this slide is important? Because these are all copyrightable. These are not patentable. Understand? These are all copyrightable. Dramatic work, musical work, artistic work. Even this presentation I can copyright. I made it for you. Specifically, I made this presentation for you. I cannot patent it, but I can make a copyright on this. I can take a copyright. Nobody should use my presentation like this. I can take a copyright on this. So something like that. So these are the 4 or 5 concepts. One is mathematical or business method, computer program. Computer program is nothing but software. Software is not patentable in India. Software is a copyrightable protection material. And then literary, of course, you know this. Literary, dramatic, musical work, artistic work, cinematography, audio, video, music, dancing, all this choreography, all these things are not patentable. These are all again artistic works come under copyrights. Mental act, method of playing. If you find a method of playing, that is not patentable. In the same way, presentation, as I told you, topography of integrated circuit, these are all not patentable in India, but there are some deviations in different countries. Even dolly kind of invention is patentable in Australia, not in other worlds, not in the other countries. Even recombinantly produced biological material is patentable in Australia, but not in US or Europe or India, even in Japan or China. Most of the Asian countries are North Atlantic, North American countries, no. But in Australia, it is patentable. So it varies from country to country. The law varies from countries to country. This is one more thing. An invention which is an effect of traditional knowledge, which is aggregation or duplication of the known property. I think I already told you about Combiflam. This is ibuprofen and paracetamol tablets. And then another one I put here is turmeric. Turmeric is a traditional substance for us. Most of our Indians know it from the childhood. From the birth, we know this. But not in other countries. In foreign countries, they don't know about what you know about turmeric. This turmeric is having antibacterial activity, you know. This turmeric is having so many other health advantages. So all these advantages, if you say that if I want to patent now, no, it is not patentable now. Because this is a traditional knowledge which is coming from years. Even my grandmother's grandmother also know that. So this kind of traditional knowledge is not patentable. This kind of duplication of properties in case of Combiflam, ibuprofen and paracetamol tablets is also not patentable. Fine. Now, who can apply for a patent? Who are eligible for a patent? I told you, first of all, I am an inventor. I am the true inventor. As a first inventor, I can apply, or as an assignee, my company or my college or my organization can apply, or the legal representative. If I cannot go or the company cannot go, my legal representative, my lawyer or my advocate or my consultant can apply for a patent on my behalf, of course, on my behalf. And then this person, who is this person means whether the first person or true inventor means who, or the inventor's assignee means who. He can be a government person means here jurisdiction person. Jurisdiction person, or I can call it as a jurisdiction person, is something like a company or a government or an association. A government of India can file a patent. Jubilant Biosys, my company, can file a patent. NRI institutes can file a patent. An association of boys can file a patent. A partnership fund can file a patent. A simple individual can file a patent. These are all eligible for filing a patent. Now coming to how it is identified. The true and first inventor is not someone who invents or who imports the invention from. The actual inventor sits in Europe, in North Carolina, and he told me over the phone that this is my invention, I want to patent it. I cannot do that. I cannot do that. I am not the inventor. So the importer cannot act as an inventor. In the same way, I have to disclose my name, nationality, everything in the patent application, so that to give the identification of who is actually the first and true inventor. Now coming to where should I file my application, my patent application? Can I file in Hyderabad or can I file in Vijayawada? No. Patent filing follows territorial jurisdiction. Territorial jurisdiction means a particular area of states are assigned to go and file in a particular office. There are four patent offices in India in all 4 metropolitan cities: Mumbai, Delhi, Chennai, Kolkata. These are the states related to these 4 places. So these states have to go and file the patent application at their patent office only. If you see in Chennai, Andhra Pradesh, state of Andhra Pradesh is coming in Chennai, I cannot go and file in Mumbai. I cannot go and file in Kolkata or Delhi. I have to file in Chennai only. So this is called territorial jurisdiction. In the same way, other way around, Maharashtra guy cannot come here and file a patent because here not guy coming here and filing the patent, where actually the invention is generated. If the invention is generated in Maharashtra, he has to file in Mumbai. If the invention is generated in Vijayawada, he has to file in Chennai. If the invention is generated in Hyderabad, he has to file in Chennai only. Okay, apart from all these states, whatever mentioned here, if anything is any other place he is coming from, he has to file in Kolkata because Kolkata is the head office. Applications have to be filed in the respective patent offices only. We cannot file wherever we like. Now, what is the procedure? How to file the patent? So my filing of the patent will come. I will have to prepare a complete draft of patent application and go and file at patent office, Indian Patent Office at Chennai, because I am staying in Hyderabad, let us say, or if I am staying in Bangalore, or if I am staying in Vijayawada. All these places are coming under Chennai jurisdiction only. So we'll have to go and file the first application in Chennai only. Then after 18 months of my filing, my application will be published in the internet, or in the previously, now it is internet is available. Now previously it is officially published in the Gazette, in the Indian Gazette. It is not granted, it is not reviewed, nothing is done. It is just you file, it is published. Why it is published means that is called pre-grant publication. Pre-grant publication, why they publish is because, see, this so and so Ravi has filed this patent application. Do you have anybody has any objection in this? So it is telling it is asking the public by making this publication. It is asking the public, Ravi has filed this patent application. Do you have any objection? Otherwise, shall I go ahead? If anybody has say that no, this invention I already come across and I know much before, of 1 year before I know itself. If you come across, show me the evidence. That is again a legal procedure, but not at court, but it is a patent office. So this can be done for the publication, and once it is accepted, once it is pre-publication is done, pre-grant publication is done before 90 days, if anybody comes against opposing this, then that will be a hold. Otherwise, they will go for studying the examination. They will file the examination. Patent office completely thoroughly studies your application, and they will call you in case they have any objections. Why you have written this claim? This is not correct. This is not valid. All these things you can give your justification. End of the day, if the patent controller is happy with your justification, the patent get granted. Okay, now that is one procedure. After grant, immediately after grant, again the application is published. That is called post-grant publication. Pre-grant publication, post-grant publication. Even post-grant publication also, within 1 year from the post-grant publication, if anybody oppose this invention, can come forward and oppose. After 1 year, nobody can oppose this patent. This has to be continued for 20 years duration of time. So this post-grant opposition or pre-grant oppositions will be done based on the publications. So once this patent is granted, not from the grant date, guys, please remember, not from the grant date, it is from the filing date. 20 years from the filing date. Sometimes this the duration between filing and granting may take place 1 year or 2 years or 5 years or 7 years also. But the term of the patent will be calculated always from the time of filing of the patent application. Clear? I am moving ahead. Now, that is one procedure for filing an Indian patent application. Here, I want to file my application in different countries. I want to file in India, I want to file in US, I want to file in Japan, I want to file in Europe. In Europe also, I want to file in Sweden, in Switzerland, in France, and also in Australia. All these countries I want to file. What is the procedure? Either I have to go to each country and file, or I have to follow a unified centralized procedure called PCT procedure. What is PCT? PCT means Patent Cooperation Treaty. Patent Cooperation Treaty. Under Patent Cooperation Treaty, this is a union of different countries, 127 countries, I think, from my last knowledge. 127 countries are there. Now maybe increased. These 127 countries are following this Patent Cooperation Treaty. In this way, what happens is, first of all, I have to file my patent application in India. That is called priority application. I filed my application in India. Then within 12 months, I will file a PCT application. Instead of filing different countries, I file a PCT application. PCT application is called international application, where Indian application I already filed before 1 year. Now, after 12 months, I filed PCT application. In that application, all these 120 countries are mentioned. You tick mark wherever you want to go. You tick mark wherever you want to go, whatever the countries you want to go, all will be there. Brazil, Gizel, US, China, Japan, Russia, Australia, all these countries will be mentioned, 128 countries. So you tick mark wherever you want to go. This application will go there. But this application will go there only when you pay the fees for that particular national. If you pay the US national, then only it goes to US. If you pay the European fees, then only it goes to Europe. If you pay Switzerland fee, then only it goes to Switzerland. Otherwise, it will not go. So tick marking is not only important, you will have to pay all the national fees also. So you have to file the national fee, then it goes to that country. That country will again review the same procedure as I told you before. It goes for examination, pre-grant publication, post-grant publication. Everything will go in the same way. Then it will be circulated once or twice with the controller, patent controller, whether it is an order or not. Finally, when the patent controller in order, the application will be granted. So the same procedure will be applied in different countries. If you file 120 countries, if your invention has got great quality, you will get 120 patents on the same invention at the same time with a one application called PCT application. That is the advantage of PCT application. Understood? This is about PCT application. There are so many regulations in this PCT application because of time constraint. I think I'm already at 3:30, so I cannot extend anymore. So let me go ahead further. So this is a concept of PCT, which allows you to file your patent application throughout the world. Coming to applications, as I told you, how should I file a patent application? See, for example, if I say I got a patent idea now, but today, but see, for filing patent application, I have to write claims, I have to write experimental part, all these things will be there now. So that will take some time. But in the meanwhile, someone goes and file a patent application on the same invention. What happens? Who will get the priority? That person will get the priority because he has already submitted the paper at the patent office. For that reason, there is a provision called provisional specification. Provisional specification does not contain any kind of claims and all or experimental part. It will give a brief abstract of your invention and submit it to the patent office. From that date, because that is the priority date, from that date, within 12 months, you have to file the complete application. Complete application, now within 1 year time, you do whatever the nonsense. Whether you develop, do experiments, write claims, take help from friends, from all the people, write a clean patent application, go and file the complete specification. But your invention, because of you filed provisional application, your invention will get priority. Even this 1 year period after you file provisional patent application, if someone comes and files also your application, because of first you filed as a provisional application, you will only get the priority. That is the difference between provisional application and complete application. Provisional specification and complete specification. So what should be involved in these specification? I will tell about complete specification. There should be a title. There should be a preamble for invention. Preamble means abstract, I can say. What is the invention? Why you have done this? I'm coming with a tablet used for so and so disease, something like that. And name and address of the nationality of the applicant, field of the invention, and then use of the invention. So Prior art means related to this particular tablet or this particular injection, what is already previously existing. My product is also same or different? My product is different, no? That we have to explain. Previously, this is existing, but my product is not existing. That is the reason I am filing a patent application. Because of my patent, what are the problems to be solved? So that also should be mentioned clearly. What is the object of my invention? What is the general statement of the invention? And then detailed description of the invention. That means experimental part and all. So all these things should be mentioned well. Then, as I told you, claims. There may be one claim or more than one claim. This is actually my invention is. Tablet everybody knows. Fever everybody knows. For fever, more than one tablet. But my tablet is something different. My tablet works in single pill for 1 week. That is the advantage. So that is the reason is so that you have to claim. And finally, you have to sign and date. You have to submit all the drawings. Drawings can be structures of the products or your engineering drawings, whatever it is. Finally, you write an abstract. What is the essence of your invention? So all these things should be the contents of your complete specification. Only the difference is, apart from this title and preamble invention, nothing will be there in provisional specification. Complete specification, all the things should be there. That is only the difference. Understood? So different types of patents are there. Again, I can say ordinary patent. If I go and file in a patent office in Chennai, that is an ordinary patent. Convention application, as I told you, once convention application, today I file in India, I don't want to go to PCT route. I want to go and protect my invention only in US. Then I will take the priority from India and file only in US. That is called convention application. PCT application, international application, I told you. PCT national phase application, I told you. Patent of edition. Sometimes what happens is you already filed a patent and you come with some invention. You come with a tablet, you file a patent application. Now you come with another addition to that tablet so that it is working much more effective way. So then you add this ingredient to that already existing invention. That is called patent of addition. Then there are divisional application. Divisional application means what? If a patent, always a patent should contain one invention. It should not contain more than one invention. If it contains more than one invention, the patent controller will ask you to divide this patent application into 2 or more patent applications. Each application is called divisional application. Understood? Coming to product patent, as I told you, as a compound, as a substance is a product patent. A process patent is a method of synthesis of that compound. Process patent is not the method of curation or method of treatment or method of operation. No. Surgical treatment. No. Process is synthesis or manufacturing process of a product. Design patent is something like that. It is not in US. It is not in India, but it is in US. Some design patent, just like Michael Jackson patent we have seen. It is a patent design of a shoe. So that kind of patents are acceptable in US. And method of treatment patent, this is also method of treatment or use patents are not in India, they are in US. Formulation patents means tablet, the ingredient in the actual ingredient, the API, what you call active pharmaceutical ingredient, that is the actual substance in the tablet is the product, but the entire tablet is a formulation. Entire tablet not only contains that product, it contains different other components. It has sweeteners, it has coatings, it has buffers, it has excipients, all these things will be there. So all these things will form a formula. Injection does not contain only that actual product, it contains different other components. So with all these components, the formula is made. That is called formulation patent. Only that main ingredient is protected, that is a product patent. This is all manufactured using a particular process. That is a process patent. Hope I am clear on this. With this, I think I am done with. If you have any questions or any other things, you can ask me. I think I am done. Vijay sir and PRK sir, I think I am done.
Yes sir. Nice sir. Any participants would like to interact? Please respond. Participants, I think they do not have the option, sir.
No problem. No problem. You can share my email ID or something with them. In case of In case of any doubts or something like that, if they
platform,
have, they can reach out to me.
Yeah, there is no option of interacting through this platform,
No
sir. Anyway,
No
then
worries.
we request them have any future clarifications or anything, then definitely they will contact you, sir. So on behalf of organizing committee, I express deep and sincere appreciation to our resource person, Sir Ravi Syam, sir. In spite of your busy schedule, accepting our invitation, and you have given excellent and motivational session, sir. Really, then how to get the patent and different things, the issues involved in getting the patent, as well as how to file the patent. So it is very, very important and excellent information, sir. I hope our students then get good information as well as knowledge, sir. So again, from the institution NRI College, and we are very, very thankful for your today's session, sir. Really, we are we appreciate you, sir.
Thank you
sir.
very much, sir. Thanks. It's nice
Thank
meeting
you, sir.
you. I think
Thank
there are
you for
about 150 people who are attending. I'm very glad. I'm very glad to give a brief
sir.
on.
250, yeah, 250 students, sir. 250 actually.
250. Okay.
Now just classwork started, sir. Now just only 60, 70 students they left, sir, 5 minutes back.
Okay.
Actually today